Monumental systems, whether mechanical, digital, or legal, remain entirely inert without a precise trigger mechanism. You can build an incredibly complex engine, but until a single pin slides into place, it has no power. It just sits there. In Malaysian property law, that complex engine is the Strata Management Tribunal, and the pin that violently activates it is found in the preamble to its governing regulations. We are going to look specifically at Part 1, Regulation 1. Most non-lawyers read a contract or a statute and immediately skip the citation and commencement clauses. It looks like administrative housekeeping, a title page masquerading as a rule. Treating this text as disposable misunderstands the architecture of a legal system. Statutes do not possess inherent authority simply because they are printed. They have to acquire it. Regulation 1 operates as a highly specific legal ignition switch. It consists of exactly 43 words, divided into two distinct subcomponents. For the rest of the document to carry any weight in a courtroom, both of these components must execute flawlessly. A legal document without a functional Regulation 1 is just ink on paper. It requires these specific syntactic triggers to cross the threshold from a theoretical text into a binding reality. To understand how this works, we need to look at the law not as literature, but as executable code. Subregulation 1, the citation, functions like declaring a system variable in programming and assigning a unique, bindable identifier. Future contracts and property disputes must lock onto this exact text target to invoke authority. Subregulation 2, the commencement, serves as the execute command, activating it. If either of these subregulations is missing, the result is a critical system failure. If you have a name without an activation date, the law remains eternally dormant. It exists in theory, but no judge can enforce it. Conversely, if you mandate an activation date but fail to provide a precise, unique name, you create jurisdictional chaos. No one knows exactly which set of rules just went live. The preliminary section is the ultimate gatekeeper. It mathematically ensures that identity and temporal activation are locked together before any tribunal powers can be exercised. Let's examine the specific string of text generated by Subregulation 1.1, Strata Management Tribunal, Regulations 2015. Look at the visual structure of this citation. We start by isolating the outer layer, Strata Management, and Regulations 2015. This framework defines the broad category of property law being addressed, mapping the general territory. Then we have the parenthetical insert, Strata Management Tribunal. In statutory drafting, parentheses are tools for nested structural subordination. By enclosing these specific words, the text restricts these procedural rules strictly to the operations of the tribunal. They are deliberately segregated from general strata management rules that apply to a developer or a local council. In law, we call this effect jurisdictional containment. If a lawyer attempts to apply a specific procedural rule from this citation to a standard civil court dispute over a strata property, the argument fails instantly. It is jurisdictionally invalid. This precision works in reverse as well, preventing the tribunal itself from overreaching into areas outside its designated mandate. Subregulation 1.1 uses nested typography to structurally fence in the tribunal's operational boundaries, ensuring the name itself limits the reach of the law. That structure is governed by an unseen force, a parent statute. Under the hierarchy of Malaysian statutory law, there is a strict separation of power between an act passed by Parliament and regulations drafted by a minister. In this ecosystem, the Strata Management Act 2013 is the supreme parent document. The 2015 regulations cannot exist independently. They draw their authority directly from that 2013 Act. The 2013 Act dictates the absolute ceiling of power for the tribunal. Everything the tribunal does must trace back up to that original parliamentary grant of authority. This introduces the doctrine of ultra vires, which means acting beyond one's legal power. If a single rule within the 2015 regulations contradicts the 2013 Act, it is void. By incorporating the name of the parent act directly into its citation, Regulation 1 structurally acknowledges its position as a dependent, subordinate framework. It functions exactly like a legal umbilical cord, continuously drawing raw enforcement power from the 2013 Parent Act. That brings us to Sub-Regulation 1.2, the engine of temporal activation. The specific operative phrase here is come into operation. Look at this timeline. There is a distinct gap between the passage of the Parent Act in 2013 and the activation of these tribunal regulations on 1 July 2015. Complex statutory regimes are rarely enforced the day they are printed. You have to establish an institution. The government needed time to hire tribunal presidents, establish filing systems, and draft the specific forms that citizens would use. That logistical reality necessitated the delay. At 11:59 p.m. on June 30, 2015, this text was a legally inert document. You could not file a claim. 2 minutes later, at 12:01 a.m. on July 1st, those same words became fully weaponized legal requirements. Sub-Regulation 1.2 is a precise temporal threshold. It isolates the exact second the legal fiction transitions into enforceable reality. Now we bring the two dissected halves of Regulation 1 back together. Sub-Regulation 1 establishes the definitive identity and subordination of the text. Sub-Regulation 2 establishes the temporal threshold. Together, they forge binding jurisdiction, the root node for the entire document. Every subsequent rule flows from this singular point. In the real world, every fine issued to a defaulting strata owner, every ruling enforced against a management body, and every dispute settled by the tribunal relies entirely on this foundation. If a litigator could somehow successfully challenge the validity of Regulation 1, the entire tribunal system would instantly collapse. There would be no legal mechanism to enforce a single ruling. The sheer force of law does not materialize out of nowhere. It only slams down with absolute finality because structural groundwork was laid. Within the architecture of the law, the preamble functions as the primary mechanism for activating authority.